Good afternoon. I am honored to join you today at the close of this important Congress and in this great city. I would like to thank Gerardo, Pablo, Ivan, and Mitzi for their assistance and hospitality in preparation for this conference. They have placed me in the enviable position of speaking before such a distinguished audience, one that is dedicated to reform in the criminal justice system using best practices and the latest research from around the world. At the same time, I'm in the very difficult position of being the last presentation before the close of the Congress and the beginning of your weekend. And so, as I must often hold back my passion for a subject in the classroom, lest I lose my students' attention entirely, I aim to keep these remarks concise and, more important, as practical as possible. Over the last 15 years, I have made the empirical study of the law my professional calling. For decades, the idea of lawyers seeking out mathematical solutions to our most pressing justice problems would have seemed unthinkable. As unthinkable, perhaps, as the technology that motivates my remarks this afternoon. And yet, there is an ever-growing group of scholars with law degrees and with statistical training searching for answers to, in its simplest form, one question: what works and what doesn't in a legal system? I've been chasing those answers in the realm of employment law, anti-discrimination law, and most recently, pretrial release decision-making as the former research director of the Access to Justice Lab at Harvard Law School. It is that research agenda, both including bail decisions and sentencing guidelines, that I will discuss here. This year, 2018, marks the 50th anniversary of the landmark Oscar-winning film 2001: A Space Odyssey. For people of a certain age, it was their first glimpse into the far reaches of outer space, a realm mankind had not yet grasped. The images and sound amazed audiences, but there was one feature that signaled the troubling side of scientific advancement: the HAL 9000 computer. An artificial intelligence system was the operational core of the main character's space vessel. HAL controlled everything on board, from navigation to life support. At first, the computer seemed like a benign presence, able to engage in conversation and even play chess. Eventually, though, it becomes the villain of the film, ignoring human commands in desperate acts of self-preservation. Eventually, the lone remaining astronaut reestablishes control and disables HAL entirely. Having watched an anniversary screening of the movie, I was struck by how prophetic it was with respect to our lives almost 2 decades after the year 2001. Humans had divided their labor and processing capacity between themselves and machines. That choice would make the age of interplanetary discovery possible. But science fiction writer Arthur Clarke and director Stanley Kubrick warned that these developments, if not used or supervised properly, could also work to our detriment. The same struggle is playing out right now, in real time, over the use of algorithmic tools in the criminal justice system. Cutting-edge research claims to have identified the factors that best predict whether a convicted defendant will commit more crime, whether someone just arrested should be released with or without money bail to ensure his appearance, even whether certain locations within a city should be policed more heavily. Not long before leaving office, U.S. Attorney General Eric Holder grappled with this brave new world. He understood the stakes for integrating algorithms more deeply in the criminal justice system. He said, and I quote, "Over the past decade, we've seen an explosion in the practice of using aggregate data to observe trends and anticipate outcomes. In fields ranging from professional sports to criminal justice, this increased reliance on empirical data has the potential to transform entire industries and, in the process, countless lives, depending on how this data is harnessed and put to use." I don't believe General Holder was wrong. In fact, he was absolutely correct. The power of these tools might be nothing short of revolutionary. It also might not change much about how prosecutors, defense attorneys, and judges do their jobs on a daily basis. But regardless of the outcome, algorithms are already reshaping the way that legal actors think about justice and how it is best achieved in the modern era. I will return to Eric Holder's words throughout these remarks as they crystallize the tension between, on one hand, improved criminal justice outcomes, and on the other, fairness to criminal defendants. I will review the core issues, first by defining what we mean by algorithmic justice. Then, I will present what I believe to be the promising and then the perilous features of these tools. And in conclusion, I will make a very firm plea to all of you here. I'll preview it now. The request is simple: to never rely on professional intuition or instinct when pursuing reform, or not to rely on that alone. Rather, I call on all of you, on members of this Congress, to work with researchers who can rigorously evaluate whether new policies and procedures actually work. Okay, I will continue. There will be some things that may not make as much sense without the slides as with them, but we'll proceed. Prosecutorial reform in the United States comes in many shapes and sizes. The recently elected district attorney in Philadelphia, a man named Larry Krasner, has brought his own background in civil rights to the office. And the reform package that he brought includes major, sweeping changes to both charging and sentencing practices. And in March of this year, Kim Foxx, who is the state's attorney in Chicago, released 6 years' worth of felony criminal case data, never before done by her office or virtually any office in the United States. That decision alone was therefore momentous. But I'd argue that Ms. Fox's purpose of furthering research into her office's work to breaking open what we call the black box of prosecutorial discretion was the truly groundbreaking choice. Alongside these changes, the most attention-grabbing set of reforms affecting criminal justice north of this border is the availability of algorithmic predictions in the courtroom. Unlike Mr. Krasner and Ms. Fox's innovations, which are usually easy to understand among lawyers and judges, these mathematical tools are much less intuitive. I prefer to think of these tools in one of two ways. One would be a list of risk factors and a set of weights for each factor. So, for example, we might have the number of previous felony convictions, the number of previous misdemeanor convictions, and then a number that goes along with that to say how important is that factor. I'm going to call this simply an advanced formula. But it's an algorithm nonetheless. And with these algorithms, social scientists have combed through often millions of criminal records to pick out the ones that best predict failure after release. They also use sophisticated techniques to understand which of those factors are more or less important. At the end of the day, these tools are designed so that any user in the justice system can plug in basic criminal history information and produce a risk score in mere seconds. but the basic formula never really changes. The second set of algorithms is still in its infancy, and I call these machine learning-based algorithms. Unlike the formulas, these tools are dynamic. They are constantly updating which inputs are most predictive when scientists feed them new data. Like HAL from 2001, they are coded to function independent of human interaction. Unlike the cinematic computer, though, they cannot think or act for themselves. Nevertheless, we should never underestimate their power. These algorithms, the machine learning-based ones, reach conclusions with far-reaching consequences for criminal procedure without continuous human input. As a result, they share some characteristics with what used to be possible only in the realm of science fiction. But regardless of the algorithm's design, whether it's an advanced formula or based on artificial intelligence, the objective is to take characteristics and the history of a criminal defendant and reduce those experiences to a numerical score. That score then becomes a recommendation for what the judge should do. So far, no U.S. state has required a judge to follow the recommendation. In other words, it remains just a recommendation, not a mandate. Most scholars think that the mandate, myself included, would be unconstitutional. But we know from behavioral economics that providing the score should have a real impact on how judges make decisions. Aha, we are back, and I will tell you now from this slide some examples of these algorithms, both of which at the moment are just advanced formulas. Two main examples of these advanced formulas are pretrial release and sentencing risk assessments. The Laura and John Arnold Foundation has developed the most widely used pretrial tool in the United States called the Public Safety Assessment, or the PSA for short. I'll talk a little bit later more about that tool. North Point created a tool known as Compass, which guides judges making sentencing decisions, again, based on defendant risk. I'm not going to go into specifics of how they work. Instead, I'm going to try to stay at a general level and give you a broad overview of their consequences. Now, since most of us prefer to receive the good news first, I'll start with the promising aspects of algorithmic criminal justice. Although the benefits that I mention here are not by any means universal, I think of them as the best that this new frontier of criminal justice has to offer. First, judges and prosecutors, they often rely on a formal charge and an associated bail schedule as a matter of formal practice. We know, too, that because they are only human, after all, that these actors might also use impermissible attributes like race, gender, or nationality. Algorithms can help reduce these biases by presenting only objective, and I put that in quotes because people do disagree about how objective they are, but I'll say for now objective information nonetheless from a defendant's past behavior. And as I noted before, the science behind the algorithm claims that the tool's inputs are the best predictors of failure. Second, some risk assessments don't use a defendant interview to create the score. In the US, there is a risk, protected by the US Constitution, that defendants will incriminate themselves when answering questions without a lawyer present. Some tools, like the Public Safety Assessment, the PSA, do not use interviews, in part to avoid that happening. And third, the algorithm's output gives the court something tangible and more transparent to rely on than just how they process information in their own minds. The judge is taking this algorithm, which itself takes in all sorts of information, processes it based on their own experience and hopefully their wisdom, and produces, for example, a sentence for this defendant in this case. The problem is that judges rarely tell the prosecution and defense about every input that generated the decision. Use of and reliance on a risk assessment can help everyone in the court focus on the same factors and understand how they were used to reach a decision. I note here on the slide that most of the tools that are in use usually have what we think of as evidence-based objective factors. There are very few. Really, to my knowledge, the PSA is the only one that does not use a defendant interview. And we know that transparency in the court, at least in the US, is severely lacking. And so I really think that the prime benefits of the use of algorithmic tools in the criminal justice system is bringing these attributes more to the forefront of the court's activity. Now, I didn't promise at the outset not to show you any math or any graphs to a room of lawyers, but I'm going to do just that. So please, bear with me. Don't be alarmed. It will all make sense in a second. In this graph, which looks complicated, you see three plots, three curves of how risky a defendant might be. Let's say we're looking at this at the pretrial release stage. The solid black line shows the distribution of risk in a fictional population. In other words, from 0 to 1 being the probability that you will fail if you're released, we're plotting what the risk of defendants out in the world might be. The problem of decision-making at the pretrial stage is that the judge doesn't know what that curve looks like. She doesn't know for sure where a particular defendant is in this risk pool. Low, medium, high risk? And so she sees the distribution in the middle, the one with the long dashed line, the one that is relatively flat. If that's the case, we know that judges are simply going to make decisions in error. And so the promise of the algorithmic tool is to make decision-making more accurate because it's based on legitimate factors. If the tools work, they might correct judges' thinking to look like the short dashed curve, almost identical to the original solid black one. This graph is my way of showing both how the tool affects information and that we might have to assume that defendant risk is either very low or very high in order to see an effect from these tools. The second graph, though, looks a lot different. In this one, I'm saying that defendants, on average, are much more likely to be medium risk. When this is the case, the noise that judges get when they look and talk to a defendant only causes them to be wrong at the low and the high ends of this graph, but not on average. And if this is the way the defendant pool actually looks, then a risk assessment probably doesn't have as much work to do. Okay, are we all right? We got through the graphs? No problem? For now, all of what I've told you based on these pictures is speculation. My colleagues and I at the Harvard Access to Justice Lab are trying to figure out precisely which picture of the world that I've shown you is more accurate, because the answer to that question will determine the effectiveness of the algorithmic tools. Okay. I'm going to return once again to Eric Holder's words. He, again, agrees with me. Data can also help design paths, for example, for federal inmates. Such evidence-based strategies show promise in allowing us to more effectively reduce recidivism. And ultimately, they hold the potential to revolutionize community corrections and make our system far more effective than it is today, by better matching services with needs, by providing early warnings whenever supervised individuals stray from their reentry plans, by incorporating faster responses from probation officers to get people back on track, and by yielding feedback and results in real time, end quote. Again, this is the promise. This is what I set out to you and I argue to you is the potential benefit of the risk assessment. But that promise has not yet at all been proved. And so, we must consider how reliance on new tools could negatively affect our foundational legal values. We already have witnessed the use of algorithmic risk assessments having dire consequences for criminal defendants. The now famous Loomis case from the state of Washington, which is discussed in this New York Times op-ed piece, challenged the use of the compass tool at sentencing. Mr. Loomis was charged with crimes that didn't require prison time at all. And yet, the risk tool suggested 6 years of time in prison and another 5 years of probation. No prison required, and yet 11 years of being under the supervision of the criminal justice system. Mr. Loomis mostly lost the case at the Wisconsin Supreme Court, but that court recognized that American due process requires defendants to have access to what the algorithm is using as its inputs. And it also requires judges to still use their human judgments and not solely rely on the risk tool. Compass also came under attack after the publication ProPublica uncovered what it believed to be evidence of racial bias in the risk scores that black and white defendants received in Florida, for example. And without assessing the validity of their study, I can say that racial bias is and absolutely should remain a focus of our work on algorithms. Differential outcomes should be driven only by differences in defendant behavior, not by differences in defendant identity. On a more conceptual level, US lawyers and academics are often concerned that any tool that is using what we call big data sacrifices core legal values. We all prize constitutional values of due process and equal protection, but I will tell you that those values are in peril if we make decisions on one defendant based not only on his data, but the data of millions of other people. That's a question we have to confront. Some even take issue with the use of defendant-specific information that can't be changed at all. For example, if a prior felony conviction is one of the risk factors, then a defendant charged with a new crime can't avoid that factor contributing to the score, even if that person served his or her prison time admirably. Once again, the former Attorney General captures the issue well. Criminal sentences must be based on the facts, the law, the actual crimes committed, the circumstances surrounding each individual case, and the defendant's history of criminal conduct. They should not be based on unchangeable factors that a person cannot control or on the possibility of a future crime that hasn't even taken place. Equal justice can only mean individualized justice, with charges, convictions, and sentences befitting the conduct of each defendant and the particular crime he or she commits. Now, what do we make of this debate? What sense can we make of it? My colleagues and I at the Access to Justice Lab have taken a page from the book of the U.S. Food and Drug Administration, We even look to the medical field. Most of you know, especially the full lawyers in the room, always think they know best. Well, we at the lab are admitting that even we, as the lawyers, might not know everything, that the profession needs to admit that it might not have all the answers. In the FDA context, the idea is that no drug can go to market without passing a rigorous test known as a randomized control trial. If you don't want to think of that fancy word or phrase, you can think of the acronym RCT, or simply a scientific experiment. The idea is really hard to implement in the law, but I think it's easy to understand. The basic idea is to take a population and to separate them into what we call treatment and control groups. The treatment group receives the new idea. For example, access to a new resource, or in this case, availability of the risk assessment tool. The control group gets whatever existed before the innovation. When we choose these two groups at random, essentially by a coin flip, we can be as sure as possible that the new idea isn't going to people because of their personal characteristics. That randomness helps us understand causality, not just correlation. After the experiment ends, we take the data from the two groups and compare them statistically to see if their outcomes were significantly different. So in the slide that you're looking at, you have groups in two colors. One is representing the treatment group, the other is the control. And because we chose them purely at random, when they go out into the world and do things, with and without the new idea, we can compare their outcomes in a very rigorous and reliable way. And then that last graph is just an example of what my colleagues and I report in papers. We're looking for a significant difference. That's it. You're now all experts in randomized control trials. Of course, I exaggerate, but my point is that these ideas shouldn't be frightening. Lawyers, judges, defendants in the legal system shouldn't find the idea of experimenting for purposes of evaluation to be something that is scary. It should be a lot more intuitive, because this evaluation technique is the most powerful one that we have. With this method, the legal profession can finally understand what works and what doesn't without relying on anecdotes and personal experiences. One last time, I share with you advice from the former Attorney General, Eric Holder. He says, at the state level, data-driven reforms are resulting in reduced prison populations. And importantly, those reductions are disproportionately impacting men of color. We should celebrate this milestone, a true turning point, and hope that front-end applications can also result in both public safety and racial justice. Careful study of this issue is warranted. I can't emphasize that enough. The former Attorney General understood the stakes. Algorithms in criminal justice carry promise, but they also carry peril in equal measure. The only way we'll know whether they are consistent with justice under the law is to study them. And that's exactly what I'm committing myself to doing as a legal scholar. I'll give you a quick example. With the PSA, I am hoping to launch up to 7 individual studies across the US, randomizing whether a judge receives the PSA recommendation or not. And then we will compare, my colleagues and I, the outcomes of released defendants when the risk assessment was made available and when it wasn't. Again, without going into too much detail, I'm trying to make the argument to you that studying the legal system in this way is our best hope of understanding what new ideas should flourish and which ones should be relegated to the dustbin of history. And so, on that point, and in closing, I want to leave you with a plea. Actually, it's not just a plea, it's a call to action, a heartfelt request to all of you. The study of the law often overlaps with the social sciences, especially my own training in economics. Great figures like Judges Richard Posner and Guido Calabresi, among other great thinkers, have transformed the profession into one better understood through the lenses of efficiency and loss prevention, but ours is not and never should become a purely scientific inquiry. Lawyers and judges must retain their inherent human discretion. As flawed as we know that is, lest we lose too much of value, too much of what makes law central to the operation of civil society. The rule of law is not just about application of these principles. It must remain a fundamentally human endeavor, administered by humans and supported by the best evidence-based practices available. How do we strike that balance between blind objectivity and professional judgment? The answer is simple, at least to me. Evaluate. Evaluate early and often. Evaluate at every single chance you get, whether it's at the federal level, the state level, or the local one. In no uncertain terms, I'm calling upon everyone at this Congress committed to genuine criminal justice reform to embrace the rigorous testing that I've talked about, alongside our good judgment as a fundamental component and driver of change. Thank you so much for the chance to speak with you this afternoon. Gracias. I welcome your questions.
Abrimos un breve espacio para efecto de los que quieran hacer preguntas.
Hola, buenas tardes. Mi nombre es Pamela Labastida. Un gusto, Christopher. Acá estoy, de este lado. Hola, ¿qué tal, Christopher? No sé si llegaste a ver la película Oblivion. 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 Oblivion.
Have you seen the movie Oblivion?
You know what?
¿Sabes qué?
I consider myself what we say is a cinephile. I go to so many movies. I actually write on the side
Me considero
movie reviews.
cinéfilo.
And you've stumped me.
Voy a ver a muchas películas
I have not
y
seen
ustedes me
Oblivion.
detuvieron, pero sí, me gusta mucho ir al cine.
Bueno, en esa película plantean lo mismo que tú estás diciendo.
¿Perdón?
En esa película plantean lo mismo que acaba de decir.
In this movie, you could see what you have just talked about.
Acerca del control de la justicia por medio de
Justice
algoritmos
control
o robots.
Using algorithms or robots.
Yes.
Y creo yo que es una manera eficiente,
I believe
ya
that
que
is a
en la
very
película
efficient
muestra
way
cómo
to
las personas
show
van a pagar sus
some
multas
people-
o van con los jueces y no más lento.
¿Cómo personas qué?
Cómo las personas
How people
van con los robots
go with robots,
que son jueces
which are
y ellos
rockets, and
simplemente dicen,
they
quiero que
simply
tenga
say,
una consideración conmigo.
I want them to have a consideration with me.
Y el robot solo contesta, el robot juez solo contesta no.
And
Paga
the
tus
professor
multas y no me
says,
interesa.
No, I'm not interested.
Entonces creo yo que
So
es
I
un punto
believe
particular,
This is
es una
particular,
manera en la que la corrupción se evita
saying
y en la que la ley se
where
aplica de
the
una
law
manera,
is enforced
un poco más justa.
in a more fair way.
Okay. So thank you very much for that,
Muchas
that comment.
gracias por ese comentario. Could you pause between sentences
Yes,
so
yes,
that I
sure.
can translate?
So let me start by thinking of a different movie.
Bueno, voy a empezar hablando acerca de una película diferente.
I imagine you and many in the audience saw the movie Minority Report.
Me imagino que usted y otras personas de aquí de la sala vieron esta película que se llama Minority Report.
That movie is not about robots.
Esa película no trataba acerca de robots,
It's about prediction.
tenía que ver más bien con predicción.
It's about seeing into the future
Más bien tenía que ver con ver hacia el futuro
and predicting when crime will happen.
y predecir cuándo va a suceder un delito.
And so I'll take your Oblivion example
Voy a tomar su ejemplo de Oblivion
and put that together with Minority Report
y los voy a juntar con ese Oblivion con Minority Report
to say that the lessons these filmmakers are telling us
para decirles que las lecciones de estos cineastas
isn't just science fiction.
no solamente es la ciencia ficción,
It's a matter of real importance for the law.
es muy importante para la ley.
If we give up too much of our judgment
Si nosotros renunciamos a nuestro juicio demasiado
to a robot,
y lo delegamos a un robot
to a human being that can predict the future,
o un ser humano que puede predecir el futuro,
we lose what it means to be nations under the rule of law.
perdemos lo que dejamos de ser una nación que vive bajo un estado de derecho.
The reason is that a nation under the rule of law
El motivo por el cual una nación vive bajo el estado de derecho
must be guided by us, by me, by you in this room, by your colleagues.
debe ser guiada por ustedes, por mí, por ustedes, y sus colegas.
We know that we don't have all of the information, we don't have the best information.
Sabemos que no tenemos toda la información, no tenemos la mejor información,
And so with these algorithmic tools,
y con estas herramientas algorítmicas
we will receive that better information.
podremos recibir esa información mejor.
But that does not mean turning over decisions to the algorithm.
Pero eso no quiere decir que nosotros releguemos las decisiones a un algoritmo.
The world of robotic overlords in the law
El-
hopefully never will come.
El mundo en que los robots dirigen la vida nunca va a llegar realmente.
Thank you.
Hola, buenas tardes. Mi nombre es Rodolfo de la O y la pregunta es acerca del uso de los algoritmos un poco más actual. Buenas tardes otra vez, me presento. Soy Rodolfo de la O. Y la pregunta va encaminada al uso de los algoritmos un poco más al presente en cuanto a que los abogados, a los fiscales, a los investigadores, sepamos usar los algoritmos para el rastreo y la valoración de pruebas, sobre todo en aquellos delitos llamados de cuello blanco.
Es que está muy mal el sonido.
¿Me escucha bien?
Así, mejor.
Ok. Entonces, la pregunta es si nosotros los abogados debemos tener un poco más de manejo de algoritmos para el rastreo y la valoración de pruebas en aquellos delitos llamados de cuello blanco. La pregunta es porque nosotros no estamos relacionados o no nos han enseñado a usar algoritmos para rastrear o valorar pruebas. No sé si usted nos podría abundar más al respecto.
I don't know if you have anything to tell us about this because we have not received formal
Is the
training for
question,
this.
should we use
Yeah,
them?
should
Okay.
we use?
Thank you very much for this question.
Gracias por esta pregunta.
My instinct is the following.
Bueno, my instinct.
My instinct is the following.
Bueno, este es mi instinto.
Algorithms of all types
Todo tipo de algoritmos
are ways of taking the complex world
son maneras de tomar un mundo complejo
and reducing those complexities
y reducir esas complejidades del mundo
to something that even the most brilliant mind can process.
a algo que pueda procesar incluso la mente más brillante.
Our brains,
Nuestros cerebros
the way that judges operate,
y la manera en que operan los jueces,
the way that white-collar defense and prosecuting attorneys,
así como actúan la defensa y los abogados de crímenes de cuello blanco,
the way they all operate
y la manera en que todos operan,
is basically an algorithm.
es básicamente un algoritmo.
But what you're speaking to
Pero lo que usted está diciendo
is the use of big data
es el uso más bien de big data o grandes datos
to find the patterns.
para encontrar el camino.
And as a lawyer scientist,
Y como científico, abogado,
I have to support,
tengo que apoyar
to some level, the use of those tools.
el uso de esas herramientas hasta cierto nivel.
And so my full answer to you
Entonces, mi respuesta para usted
is that the algorithm and the patterns it finds
es que el algoritmo y los patrones que encuentran los algoritmos
is the starting point.
son los puntos de partida.
It can't be the last thing that the lawyer relies on.
No puede ser lo último en que confíe un abogado.
What the data show
Lo que muestran los datos
sets up the question of whether the law has been broken.
establecen la pregunta si se ha violado la ley o no.
But it takes the lawyer and then communicating with a judge
Pero se necesita un abogado y después se necesita comunicar con el juez.
or a jury
Forgery.
or a jury
Forgery.
or a jury.
O un jurado.
It takes the lawyer making an argument based on legal principles.
Se necesita que el abogado base sus argumentos en los principios legales
To translate what the data show
y traducir lo que muestran los datos
into something that we can recognize as viable under the
en
law.
algo que nosotros podemos reconocer como que es viable.
So in conclusion,
Así que en conclusión,
I support the use of algorithms in
Apoyo-
white-collar crime.
apoyo el uso de algoritmos en la definición de un delito,
But it's only shining light on where the behavior is, not if it's illegal.
pero solamente da luz en lo que es el delito y no el not what?
Not illegal.
Y lo que no es legal.
Thank you.
Buenas tardes, Christopher. Muchas felicidades.
Congratulations,
Mi nombre es
Christopher.
Eduardo García
I'm Eduardo García.
y entendiendo que el derecho es argumentativo
I
y sobre
understand
todo
that
racional,
law is argumentative, specifically rational.
mi pregunta es enfocada,
My question
el algoritmo
is-
en la justicia penal,
Algorithm in criminal justice.
¿qué límites podría tener?
¿Qué?
¿Qué límites
What would be the limits
tiene?
of the
Y sobre todo
algorithms,
en la decisión de los jueces,
specifically in judges' decisions?
que ya nos explicaste que podía abonar
You say that
en algunos temas como la
It could
discriminación.
help in discrimination.
Sin embargo,
However,
considero
I
que
cons-
el algoritmo
I
se
consider
nutre
that,
de la información humana.
pardon?
El algoritmo se nutre de la información humana.
Algorithms is being fed by human information,
Y la decisión judicial tendrá que estar basada más que en el algoritmo
based rather than
en
on
los
algorithms.
argumentos
It is based on
y razones válidas,
allegations
ya sea del abogado o del juez.
of the judge or the
Entonces, ¿qué
attorney.
límites podría tener ese algoritmo y si podría tener fallas, e inclusive en la apreciación del algoritmo?
¿Sí puede qué?
Si podría existir fallas
If there
en el
could be a
algoritmo como tal
failure in the algorithm,
y generar sesgos en la decisión judicial
or
o en el
bias
argumento del abogado.
decision.
Wow. Thank you. That's a lot to think
Bueno,
about.
me dio mucho en qué pensar.
Let me start with one statement you made.
Quiero empezar con algo que dijo.
You claimed that the law is rational.
Usted dijo que la ley es racional.
I know enough as an economist,
Como economista sé bastante
as well as being a lawyer,
y también como abogado,
that the law is far from rational.
que la ley es más allá de lo racional.
Most of the time, it is.
Gran parte del tiempo lo es.
And one of the reasons why it's not
Y uno de los motivos por los que no es racional
is both one of the flaws of the system
es tanto por los defectos del sistema
and also what makes it
y también lo que hace
one of humanity's greatest inventions.
lo que lo hace una de las invenciones más grandes del humano.
The fact that we, as fellow citizens,
El hecho de que nosotros como ciudadanos
sit in judgment of each other.
podemos juzgarnos los unos a los otros.
When we introduce these algorithms,
Cuando introdujimos estos algoritmos,
the limit has to be
el límite debe de estar
that the algorithm is only used
que solamente se utilice el algoritmo
to make predictions
para hacer predicciones
that are not required to be followed
que no requieren que sean seguidas esas predicciones
by any actor in the legal system.
y que nadie lo siga en el sistema legal.
The way that I prefer to think about these tools
Yo prefiero pensar en estas herramientas de esta manera,
is it's another lawyer in the courtroom
que es otro abogado en el tribunal
making an argument just like a prosecutor or a defense
que
attorney.
está presentando un alegato como un fiscal o como un abogado de defensa.
Regardless of how it does it,
No importa cómo lo hace,
whether it's artificial intelligence
ya sea como inteligencia artificial
or an advanced formula,
o con una fórmula avanzada,
the rule has to be the same.
la regla tiene que ser la misma.
Receive the information,
Es recibir la información,
process it alongside your discretion,
procesarla junto con su discreción
and hopefully make more accurate decisions.
y así tomar decisiones más precisas.
If we go any farther than that,
Si vamos más allá de eso,
we will lose what makes any justice system like the ones in the US and
vamos a
Mexico
perder lo que cualquier sistema judicial en Estados Unidos o en México
so very special.
hace, lo que hace que sean tan especiales. Vamos a perder eso.
Thank you.
Buenas tardes, soy Claudia Indira Contreras, vengo de Sonora y quisiera saber
I would like to know
si los algoritmos
if algorithms
podrían servir
can serve
para evaluar
to assess
el riesgo en el que pudiera estar una víctima de violencia
risk
familiar
of a victim of family violence.
y que se convirtiese en un feminicidio,
It could
en la muerte de una mujer,
come, ¿en la qué?
en la muerte de una mujer, un asesinato,
Could be an element in the death of
feminicidio le llamamos acá,
that can become a feminicide or
Es,
the death of a woman.
dado que tenemos un banco de datos
Because we
de
have a data bank
de dictámenes psicológicos que
With,
evalúan a la
psychological,
víctima o al agresor,
dictámenes psicológicos
sí, que nos dan un perfil de la víctima,
that allow
de la situación de violencia y del agresor.
that tells us about the situation of violence of the victim.
Thank you very much for that question.
Gracias por esa pregunta.
I'm actually going to answer your question and one that you didn't ask.
Voy a responder a su pregunta y a otra pregunta que usted no preguntó.
First, the question you asked.
Primero, la pregunta que preguntó.
Absolutely,
Absolutamente.
we can create new risk assessment tools
Podemos crear nuevas herramientas de evaluación de riesgos
that try to predict
que tratan de predecir
whether someone will commit a specific type of crime.
si alguien va a cometer un delito específico.
To do so
Para poder
requires
hacerlo, se requiere
new science.
una nueva ciencia.
It requires asking a researcher
Requiere que se le pregunte a un investigador
to go back to the millions of data points
para que pedirle más bien que regrese a diferentes datos
and figure out which factors best predict that type of violence.
y averigüe qué tipo de factores van a determinar ese riesgo.
In fact, in the United States,
En Estados Unidos,
researchers are doing that very thing.
los investigadores están haciendo precisamente eso.
We can essentially have
Esencialmente podemos tener
as many risk assessments
cuantas evaluaciones de riesgo
as there are types of crime.
como tipos de delitos.
But I would caution
Pero yo les digo una advertencia
that we don't want to create new assessments
que no queremos crear nuevas evaluaciones
until we understand
hasta que entendamos
whether the ones we have actually work.
si los que tenemos realmente funcionan.
The experiments that I am helping run
Los experimentos con los que yo estoy trabajando
ask about committing any type of crime
hacen preguntas sobre la comisión de cualquier tipo de delito
and then violent crime in particular.
y después delitos violentos en particular.
And only when we get results from those studies
Y solamente cuando obtenemos resultados de esos estudios,
and figure out whether they made a difference,
averiguamos si marcaron una diferencia o no
should we take the next step
y si debemos de tomar el siguiente paso.
and create more specific risk assessment tools.
Y así crear nuevas herramientas de evaluación de riesgos.
Now, the question that you did not ask.
Ahora la pregunta que no hizo.
I hesitate to talk about this, but I feel like I must.
Realmente pienso que debo de hacerlo, aunque me
One of the-
detengo un poco.
One of the concerns
Una de las inquietudes
is that judges making release or sentencing decisions
es que los jueces que toman decisiones de dictar sentencia o liberar a un inculpado
will let out the wrong people.
van a liberar a las personas equivocadas.
The risk that I tend to care about
El riesgo que a mí me interesa,
just as much
tanto como
is keeping the wrong
igual-
people in.
de igual manera, es que se mantengan en prisión a las personas equivocadas.
And this is one of the key misunderstandings of risk assessment tools.
Y esto es uno de los males entendidos de las herramientas de evaluación de riesgos.
Without a risk assessment,
Si no hay una evaluación de riesgos,
there is a risk
existe el riesgo
of letting out or keeping in
de liberar o de mantener a alguien en prisión
the wrong person.
y que sea la persona equivocada.
A judge could let someone out
Un juez puede liberar a alguien
who then goes on to commit domestic violence.
que después cometa delitos de violencia doméstica.
If that's true,
Si eso es cierto,
we expect the same thing
vamos a esperar lo mismo.
to happen with the algorithm.
Podemos esperar que lo mismo suceda con el algoritmo.
Because if the rule is that humans make the final decision,
Porque la regla es que los humanos son los que deben de tomar la
there
decisión
will
final.
always be error.
Porque siempre va a haber un error.
The hope
La esperanza
is that the algorithm
es que el algoritmo
will reduce the amount of
reducirá
error.
la cantidad de errores.
So when people talk about these tools
Así que cuando la gente habla de estas herramientas,
as if they are going to create widespread criminal chaos,
como si fueran a crear un caos,
ask yourself,
ahora pregúntense,
what world do we live in now?
¿en qué mundo estamos viviendo ahora?
Do you prefer it to one that is guided by more objective information
¿Lo prefieren contra uno que está guiado con información más objetiva
or not?
o no?
Thank you.
Gracias.
A continuación, el secretario general académico del INACIPE, Rafael Ruiz Mena, hará entrega del reconocimiento a Christopher L. Griffith Jr. por su participación en este evento.
Recognition for participating in this event.
Thank you so much. Thank you. Thank you very much.
De la misma manera, llevará a cabo la clausura de este Congreso Internacional.
Aprovechando entregar a Christopher el reconocimiento y un paquete de libros en nombre del Instituto Nacional de Ciencias Penales, también aprovechar 2 minutos para dirigirnos a ustedes y dar formal clausura a los trabajos de este Congreso y no sin antes agradecerles haber atendido la convocatoria. Creemos que es un tema que en este mismo momento es pertinente y relevante porque algo pasará con la institución del Ministerio Público Federal en los próximos meses, sea en la forma de una fiscalía autónoma como está señalada actualmente en el artículo 102A, o a la manera en que la conocemos ahora, o algo intermedio, pero algo sucederá en los próximos meses. Y creemos que los temas que se abordaron en este Congreso son de la mayor pertinencia para abonar y ayudar a la toma de decisiones sobre este importante tema. Como dijo Gerardo Laveaga, director general de INACIPE, hace unos minutos, la idea es llevarnos estas ideas a nuestros centros de trabajo, impulsar las que nos agraden en los foros y centros de discusión a los que tengamos acceso para lograr lo mejor para nuestro país en esta materia. Siendo así, si usted me lo permite, nos ponemos de pie para clausurar formalmente los trabajos de este Congreso, nuevo modelo de fiscalía hacia la gestión eficiente de la justicia penal. Y siendo las 14:25 del día 31 de agosto de 2018, se da la formal clausura de los mismos. Gracias.
Gracias.